Hello, it's Bernard Nomberg coming to you another episode of NOMBERG Law Live. Now, this is not a traditional Tuesday. I'm in my buddy Kit Belt's law office, and he and I are going to talk about insurance and bad faith insurance. And before we get that, I want to welcome you, Kit. Kit's a longtime buddy of mine, attorney right down the street from our firm. Kit, if you would, introduce yourself a little bit, talk about yourself and your practice.
Yeah, so my name is Kit Belt. Keith is my real name, and my law firm is Belt and Bruner, and we handle a variety of different matters. You know, we accept a variety of matters from personal injury type stuff all the way to business disputes, contractual issues, insurance, and really everything in between.
And Kit has, and his firm just has an outstanding reputation. And guys, that's why I'm here today. Not only is Kit a longtime buddy of mine, but over many years we've sent cases to Kit, and he and his team really do a great job of analyzing if there's a case to pursue. And that's what brings us to today's topic. We're talking about insurance, why we have insurance, the necessity for it, and then toward the end we're going to talk about some of the issues that are derivative claims that may occur when bad faith occurs, when things don't go the right way or the way that we expect them to if we have a policy or a contract of insurance. For those of you just joining us, watching us live or watching us on replay, we're listening to attorney Kit Belt with Belt and Bruner here in Birmingham. I'm right down the street from Kit. He's a longtime buddy of mine. He's an outstanding attorney when it comes to insurance claims, bad faith, and other types of cases representing the injured and those who need it most. If you've got a comment or a question that you want to ask Mr. Belt, please throw it into the comments section. At the end, we're going to put all of Kit's contact information so you can call him or look up his law firm online. So Kit, let's start with just a very basic definition of what is insurance and why do we in general need it?
Okay, so insurance is a contract that you as a consumer would enter into with an insurance company whereby you pay a premium. In exchange for that premium, you get basically a contractual agreement whereby they agree to either compensate you for a given loss scenario, or that they agree to defend you and potentially compensate someone else who may have been harmed by your negligence or malfeasance. So it's really a contractual protection that you buy to give you peace of mind for both your own losses as well as, I guess, your own losses that could be precipitated by a third party to whom you may have done harm.
And there's all types of insurance. There's homeowners insurance, there's disability insurance, there's automobile insurance, there's, 100 different types. But what we're going to focus on, what we're going to limit our talks to, is in that area of liability insurance. Now, Kit, give us just a couple of examples of what are some scenarios when a person would have liability insurance and what they may protect you or help you with.
Okay, so really the two main areas where a consumer would encounter that would be with homeowners coverage potentially, and auto coverage would be another obvious example. So with regard to driving your car in Alabama, we have mandatory liability insurance. And the reason for that is that the legislature deemed that we need some protection as consumers, that if we're going to get out on the public roadways, that we could be harmed by someone who makes a mistake or, acts in a reckless manner. And because of that, there has to be some sort of financial net there, hopefully to compensate the person and conceptually to protect the other person. But in the context of our conversation, you would buy insurance to protect you should you make a mistake, or if you're a family person and you're buying insurance for your family, that anybody in your household who may be driving the car could make a mistake. And the purpose of that coverage is that should you make a mistake and someone who you harm, either in their property or their person, makes a claim against you, you turn that over to your insurance carrier per the contract, and they have two primary duties. The duties under a liability insurance policy are number one, and the foremost paramount duty is their duty to defend you. And that's a defense against the claims being made against you. Their secondary but equally important duty is the duty to indemnify, which is that if in the defense of the case that you lose the case and you are required to pay money damages, that they would then pay the money damages under the contract up to the limit of liability in the policy.
Okay, I want to pause that line of thought, and we're going to come right back to that. But when someone has automobile insurance, and you frequently hear the term, well, I'm fully covered. Well, Kit, what does that really mean? What does fully covered actually mean, and what should it mean?
So normally, if you are told that by an insurance agent, what fully covered means is typically talking about the range and types of coverages provided. So full coverage in Alabama would typically involve comprehensive coverage, collision coverage, med pay coverage, uninsured, underinsured motorist coverage, liability coverage. Then you have some other tangential, glass breakage, towage, and some others that some carriers provide and others don't. For our purposes, I don't think that's important.
Right.
But those are your primary coverages. And of those primary coverages, you've got those broken down into first-party coverages and third-party coverages.
And then within that, for a coverage to apply to a situation, let's say you've had a car accident, you took your eye off the road, you hit somebody, they're now suing you. What if your premiums aren't paid up? And well, I guess I should ask you this, what are premiums, what's the purpose, and what if they're not paid up at the time of the accident?
So depending on the nature of the policy, most auto insurance policies, which is the area that we've been talking about, it's going to be an occurrence policy. And what that means is that you had to have insurance, valid insurance contractually intact on the date of the accident, which prevents fraud of someone having a wreck and going out and buying insurance after the fact or something. And so as long as you have a valid insurance policy in effect at the time of the wreck, then you should be covered. And to have a valid contract in place, you would need to have paid your premium, be up to date, and all those type of things. And of course, if they've tried to reject your coverage, if they don't timely reject and things like that, there can be coverage issues that arise that's beyond the scope of this discussion today. But generally, as long as it's intact, you should be okay.
Let's assume that our policy is in place at the time of the accident that we have unfortunately caused. The other party who you've hit has damages. They have property damage as well as some personal injury damage, and they're now making a claim against you. What are your responsibilities at that point toward your insurance company?
All right, so first off, your insurance company is going to require that you give them timely notice. And the reason for that is that it allows them to make a reasonable and timely investigation into the claim. And an insurance carrier is going to make sure there's coverage intact, make sure the type of claims are covered by the policy you've purchased, make sure it's within the time period of coverage. Then they're also going to assess and want to know the degree of damages suffered by the other party, and they're going to want to investigate the liability feature of the case, meaning are you truly at fault legally, are there defenses available to you, and all of those types of things. So they're going to want to look into all that. So the most important thing if you have an accident is to timely put your carrier on notice so that they can do all of those things to check all those boxes so they can then proceed forward with providing you with possibly defense or indemnity.
Is it in your best interest in this scenario to not only communicate what happened to your insurance company, but also to work with them, to be in communication with them?
Yeah, in fact, it's actually required. When you have an insurance policy with an insurance carrier, you have to comply with them in their request, reasonable request, and that is a mandatory part of the policy. And in fact, if you don't do so, you can actually lose your coverage if you have not cooperated. It's a cooperation clause is what they call that.
And if for that reason or any other reason you lose coverage, what does that mean?
Well, that could mean that you are now in a liability scenario where you have potentially caused damage to someone and you don't have an insurance policy that would be required to indemnify, because if the coverage is nullified due to a lack of cooperation, then you're not going to have indemnity coverage to provide for you if you have a judgment rendered against you.
And so that can make you personally responsible to satisfy any monetary damages or awards.
Sure could.
Okay. Let's get back on track in our scenario. We have fully paid up our premiums. The contract was in place. Unfortunately, we caused a wreck. They're investigating. Our insurance company is now trying to figure out how to defend you in this case. typically, do you have to go find your own attorney, or does the insurance company provide counsel to represent you in your interests in this case, assuming a lawsuit is filed?
Right. In your standard auto insurance policy by most of your standard carriers, you do not get to pick your own lawyer. They will provide a lawyer to you. And that's how it's typically done. So you turn the claim over to them, and they will have a lawyer reach out to you, who would be your appointed lawyer by the insurance carrier. They're paid by the insurance carrier to defend you. And an important part of that relationship is that legally that lawyer's duty and obligation is to you, even though the insurance company's paying them. And I do believe that as a consumer, if you find yourself in a liability scenario, it is important to make sure that your lawyer knows to keep you up to date on the claim, particularly as it pertains to offers of settlement, or if the degree of injury of the people that you hurt is severe. The more serious the claim is, the more you want to be in the loop to monitor your lawyer, but also the insurance carrier and how they're handling the claim.
All right, so far in our scenario, everything is working the way that it should by operation of contract, by operation of law, and the expectation of the person who's insured. But let's go off the rails now. Let's take a scenario where something doesn't happen the way that we would expect it to do. Meaning, well, I'm going to turn it over to you, Kit, and I want you to give us a scenario that we commonly know as bad faith. Tell us, what is bad faith, and why is it so important that we be knowledgeable about this area of the law?
Okay, so I'm going to talk about in the context of the liability policy, which is how we've been having this discussion. And in that context, the way bad faith can arise is in a bad faith failure to settle. And that hypothetical would consist of, say, the following. Let's say you've looked at your phone or your radio, you run a red light, you hit somebody, they're seriously injured. In that context, at some point in time, particularly in a clear liability case, presumably the claimant, the injured party, or their lawyer will reach out to you or your insurance carrier and want to resolve the case. And if they are willing to resolve the case within the policy limits that you've purchased, which is variable depending on how much coverage you want and how much available liability limits there are. And in that context, a duty potentially arises for the carrier to settle. However, some carriers, and in some instances, believe they have a good defense to the case. They think the damages are not as severe as maybe the claimant claims. Obviously, they've only underwritten whatever those risks are. They don't necessarily want to pay that full amount. And sometimes you can get scenarios where the insurance carrier refuses to tender policy limits and result to those types of demands. And they push the case to trial, and sometimes that happens and you go to trial, and then the jury comes back with a verdict in excess of the limits that were underwritten by the carrier that you purchased. And then you've got the real
Let me pause you right there.
problem.
Let's do let's give a monetary example of that.
Okay. So let's say you purchased 100, 300 liability limit car insurance. That would mean that if you injured people in a car, that's $100,000 max available per person, $300,000 max available for however many people are involved. And so that would be your limit. So if you have an accident with one person, they made a policy limits demand. We demand your $100,000 policy limits, and for that we will let the insured go, which would be the person that bought the insurance. The insurance carrier says, no, I think the case is worth $60,000. They go to trial. The jury says, well, we find against the plaintiff, the defendant rather, for $200,000. Legally, at that point, the insured now is on the hook for the additional $100,000 because contractually the insurance carrier is only required to pay the $100,000. However, because the law of bad faith exists, is if the case was a case that reasonably should have been settled before judgment for the policy limits, and it could have been settled for that amount, which is a critical component. We call that causation legally. Then the insured, who is now on the hook for $100,000, has potential legal claims against the insurance carrier. for their failure to settle the case. And those claims fall in two predominant areas. One is negligent failure to settle, which is a surprisingly good piece of law for consumers in Alabama, which doesn't have much good law for consumers, that allows you to sue an insurance carrier who fails to settle your case, and all you have to prove is they were negligent, which means they didn't act as a reasonably prudent insurance carrier under the circumstances, which, to be honest, is a fairly low threshold legally. And you also have the ability to sue them for bad faith. Bad faith means you have to prove that when considering all the facts and circumstances and the totality of those circumstances and how they handle the claim, that they acted in bad faith towards you, the insured. The benefit of that claim is distinguished from the negligence claim, is you can actually get punitive damages potentially, which allows you to not only recover the money you owe, which at that point is the extra $100,000. You also be able to recover mental anguish, which is the stress and strain on you of having to go to trial, having to sit there and get hit with a $100,000 extra verdict that you're on the hook for, and all the stress that would cause, as well as possibly with bad faith punitive damages to punish the insurance carrier for not only mishandling you and your claim, but hopefully to deter them from doing that to others in the future.
And so you've been sued by the person that you hit. You hoped that the case would get settled before a judgment. Case didn't settle. It went to trial, got a judgment in excess of your policy limits. And now you have a claim against your own insurance company in one of those two scenarios that you just explained.
Right.
What do the typical juries think in this scenario when an insured person has to sue their own insurance company for one of these bad faith type claims or negligent failures to settle?
So those cases can have really good jury appeal, because one thing that most people understand, although the average person can't really discuss the intricacies of the coverages they get, really what they're buying is a promise. You know, they're paying their hard-earned money for a promise that should I make a mistake, I'm protected. And that's the way these companies sell these policies, and that's what they represent to you in TV ads and everything else. And so juries are receptive to these claims, because the other issue that comes up in these cases is when you do get sued, you turn the claim over to your carrier, they hire the lawyer, they're involved with the lawyer, they're involved with the claim, and you oftentimes sit back and expect everything's being taken care of, and oftentimes you're not really kept in the loop. You just kind of think it's getting handled. Then all of a sudden you turn around and you owe some exorbitant amount of money that you never anticipated owing, and you weren't really in the loop. So juries, I think, are sympathetic to that, because jurors could envision themselves being in the same predicament and, you know, not being aware of what's going on, and the insurance carrier really just not holding their promise, but not doing what they're supposed to do. And not to mention, a lot of people have had, in the course of their life, a bad insurance experience, whether it's health insurance, disability, liability, whatever it may be, property damage. You know, most people have had a bad experience at one point in time, so they understand. So I think they are good cases in that context, but you don't want to find yourself in that position if you can avoid it.
Well, Kit, thank you for educating us today. This is such a complicated area of the law, but as you heard right here from one of the very best, he breaks it down so easy to really to understand the basic tenements of what these type of cases are about. Kit, one more time, if you would, tell folks how they can get in touch with you or your firm, whether it's somebody who thinks they have this type of case, or if it's an attorney out there who doesn't handle these type of matters but wants your team to look at one of these cases.
Sure. So we're located here in Birmingham on Montclair Road. Belton Bruner is the name of the firm. We're very present on the web. If you look on the web, you can find us. But our telephone number is 205-933-1500, and we've always got somebody available to answer questions.
And even though you're based here in Alabama, you really have handled cases really all over the country, haven't you?
Lots of different states, and we've got lawyers in my firm licensed in 9 states.
Very good. Well, guys, as we do always, we try to bring to you interesting information from interesting folks, whether they're lawyers or folks in the community. And really, you can't hear it any finer than this man right here. He's a friend of mine, but he's also an outstanding attorney in the area of insurance, bad faith, and those type of cases. Thank you again for tuning in and listening to us and being educated a little bit. I certainly was today. as we try to every Tuesday, NOMBERG Law Live, 10 a.m. Central, 8 a.m. Pacific. Hope you guys have a great rest of your week.
Thanks, Bernard.